Good morning, Mr. Thompson.
Good morning, Chief Justice Marshall, Associate Justices. My name is John Thompson. I represent the appellant Robert Foxworth in this case. With me is my partner Linda Thompson.
Good morning.
May it please the Court. This is a case that we thought we were going to be arguing on the merits in this court in 2003, and instead of that we've been litigating it in the federal court as a habeas corpus case for the past 6 or 7 years, and the case is now back to this court on a certified question by the First Circuit. The gist of the question is, when did the direct review process in this case end? We think that the Court's answer to the First Circuit should be that it ended when the application for further appellate review was denied on September 6, 2002.
Mr. Thompson, did you mention Gray versus Maryland in the application to late file?
Yes, we did, Justice Spina.
Okay.
That was actually, we had two arguments about Gray. First of all, that Gray established that Mr. Foxworth is entitled to a new trial on Bruton grounds, and secondly, that that this court had a constitutional obligation to take the case and apply Gray because of the rule of Griffith versus Kentucky that said that he was entitled to the benefit of the Gray rule because his case was still on direct appellate review. Now that was the Commonwealth did not litigate that issue in the Alifar proceedings, which went on for 2 years.
Mr. Thompson, do you think if this were decided adversely to you or your client, would your client be able to file in state court, given Gray, a new motion for new trial? I mean, is there any prohibition against that?
I don't believe there is, Justice Botsford. I think that the only prohibition would be that would arise if it were determined that the Gray issue or that the Bruton issue had been decided against him on the merits. I think that there's a difficulty.
But the appeals court decision was before Gray was decided.
The appeals
correct?
court decision was before Gray was decided, but Gray is not a new rule. So it might be difficult. That is, there might be some question of whether the issue is still open for Rule 30 review because the Bruton issue, the fundamental issue, is a Bruton issue. And I think it's important to recognize here that one of our arguments in the First Circuit and in the Supreme Court, and I think it has a bearing here, is that under Bruton, he was entitled to a new trial. Our position is that Bruton and Richardson, before Gray, made this.
But you've got two courts against you on that right now.
We do have, and we don't need to have that ruling. But I think it's important to recognize that what this court is being asked to do, in essence, is to decide this case.
Mr. Thompson, let me ask you what I think is, and I apologize, this may actually be the same question that Judge Botsford just asked you. If we had denied the application to late file,
yes,
you could then go back and file a motion for new trial, right?
I think we could, yes.
In what would the standard be? I assume you would allege ineffective assistance of counsel because counsel didn't file a timely application for further appellate review.
That would be one of the claims.
What law would we apply in a motion for new trial?
I think that you would. I think that the court would apply the
law at the time of the alleged ineffectiveness.
That's right.
So Gray, at least the case, you say that it's not that the law was around before that, but at least Gray would not apply to those proceedings.
Well, I think that the question would still be, when did the direct appellate review end?
No, I'm saying if we had denied.
If you had denied the motion for leave to file late.
Yeah.
I think at that point,
would you not have to go through two loops? First, you'd have to decide whether he was ineffective.
Yeah.
Yes.
Then, if he were ineffective, you wouldn't get to the Gray issue, I suspect. Then you would decide if he was ineffective. If he was ineffective, would you then get a new trial? If you got a new trial,
then you're back, then you do get the benefit of Gray, correct? In other words,
Yes, but the question of whether he was ineffective would be,
only whether he had failed to file late, because if he had, Gray is in 1998,
yes.
But you would still have to show substantial risk of a miscarriage of justice.
Well, he would have to show that the lawyer made a serious error that prejudiced the outcome of that proceeding, which would have been the Alifar proceeding.
Yeah, so in other words, you would have had to have shown that he would have won the appeal if he had won the further appellate review proceedings if he had filed it.
Well, and assuming that we haven't changed the date of when the Alifar application was filed, that it was filed in 2000.
no, it was filed, but that was late. The original FAR application, what's the date of the...
1996 was the appeals court decision.
The appeals court decided the case in
October 1996.
October 21st,
so he would have had 20 days.
Yes.
And so we would have either allowed it
Yes.
or denied it. I'm not talking about late filing. I'm talking about the
Yes.
merits of the FAR.
Yes.
Right? If we had allowed it and given him a new trial, he would have gone back, and it's possible that, in fact, it's very likely that Gray would then have been decided while his case was either being tried or on direct review. Correct? And he would get the benefit of Gray. If we had denied it, in other words, if we had agreed with the appeals court back in 1996, he would not have had the benefit of Gray, correct?
He would not have had the benefit of Gray, but as this court said in the Bacigalupo case that was decided a few months ago,
Yeah.
back in December, there were a number of cases that were decided in the late 80s that presaged Gray. As Justice Cowan said, the logic of Gray is clearly evident in not only in Bruton, but in Richardson versus Marsh. And there are really two aspects of Bruton once you get to Richardson, and that is it's not only the statement that's made that can be directly and powerfully incriminating, but the manner of presentation, which is a large element of this case. That is, not only was there a confession or an extrajudicial statement by a non-testifying co-defendant, but the way the case was presented to the jury, the prosecutor and the police officer who testified about the statement made it clear to the jury that it was a redacted statement. And the other defense counsel established through the detective that that Mr. X was not the co-defendant Christian who ended up being directed out. So circumstances and the manner of presentation, as well as the statement itself, also pointed directly to Foxworth. And in both Richardson and Gray, those elements were present. In Richardson, actually, the Supreme Court held that the redacted statement was not powerfully incriminating because it was completely redacted. There was no reference at all to the existence of Marsh or even another person being involved in Marsh's situation. But they remanded the case to the Seventh Circuit for consideration of whether the prosecutor's presentation, suggestion to the jury that they look at that statement to evaluate Marsh's testimony was a ground for relief. And the only issue they left open was waiver.
Mr. Thompson, can I just move off the merits? I know you don't want to because your merits claim is a substantial claim.
Yes.
But I will just tell you what our practice has been, and you tell me why the suggestion of the Attorney General is not an appropriate one. There's a very short period of time within which to file an application for further appellate review, a comparatively short period of time. And I would say that we have been liberal in allowing applications for further appellate review. I haven't run the statistics, but I think that's the case. And so it is not unusual to find that we allow the motion to file the application late and then deny the FAR.
Yes.
Right? I mean, so that in a way it's a way of saying to defendants, we'll take a look if there's a substantial claim We don't want to get into have to go through, wheel turning to see whether it was effective or ineffective or why it wasn't filed and so on and so forth. So that's number one. Number two is the law is very clear that if it is open on direct review, you get all of the benefit of all of the change in the law.
Yes, I think that's clear.
Why would the Attorney General's solution, which is that that if we grant the application for further appellate review, then the case is clearly still going along, and it might be that you get the benefit of changes in the law that may have nothing to do with the reason why we granted further appellate review, but at least we know that the case is going on, as opposed to saying if we don't grant it, the allowance of the motion for the late filing does not extend the time for direct review. What's the problem? Not in your client's case, but you represent lots of defendants out there, so what's the problem with that?
Well, I think that it is that it makes the question of what the proceeding is very mysterious.
But won't it discourage us from the liberal granting of late applications for further appellate review?
To say that is an extension of the direct appellate review?
Yeah.
Yeah.
Well, I think as a practical matter, it is an extension of the direct appellate review process. That is, it's the bridge, and it would be saying, well, there's direct appellate review ended when the appeals court made its decision, and then Rule 23 went into effect, and then there was a period of time, and then the court decided. Then the court took the case. Well, in this case, there was a 2-year period of litigation.
Yeah, but the consequences of, if you prevail, the consequences may be that, and I'm not saying that they will be, but the consequences could be that there will no longer be an allowance of a late application for further appellate review.
Put it this way.
I don't.
Can I just add on a second question to that? Is if we don't allow the motion for the late filing, can we look at the application? The one, at least so far, the one has preceded the other.
Yes. I don't see any reason in the court's rules why it couldn't look at the statutory factors in deciding whether to allow the late filing.
But isn't that putting the cart before? It's contrary to every rule in civil or criminal procedure that first you figure out whether you're taking jurisdiction to look at it, then you look at its merits.
I think you're right, Justice Botsford, and I don't think that this is a problem for the one reason, and the reasons are illustrated in this case. This is an adversary process. Under the rules at any rate, Mr. Foxworth had to come forward with a good cause shown case, which he did. He filed an affidavit in which he explained the circumstances beyond his control prevented him from filing his alifar earlier. At that point, the opposing party is free to challenge that showing. And if the showing is successfully challenged, the further appellate review is not allowed to be, the application is not allowed to be filed. If there's going to be some other injustice in allowing the proceeding to be restarted that late, there too the opposing party can say, this is going to prejudice us in a specific way, which we can show. That's the way this system could operate.
What are the outer parameters, though? How late could an application for late review be filed?
Well, as far as
years later, claiming ineffectiveness?
This is 4 years.
I know. So what I'm saying then is that if we adopt your position, would that permit people to reopen convictions to get the benefit of new laws that came along much later?
Well, that is something, like I said, that could be addressed on a case-by-case basis.
But would be, according to you, would be reopening, direct appeal, it would have been pending, and people could just wait until the law changed in their favor and then file an application for late FAR.
They could, and the
I
Commonwealth...
take it your position, that's up to the Commonwealth to decide whether it wants to Did the Commonwealth file an opposition to the late filing?
The Commonwealth did nothing in this entire 2-year proceeding.
But
They didn't say, there's a new case here. We don't think he should get the benefit of it. It looks like he's manipulated. Although here, there's no question that he did not manipulate the situation.
No, I'm not
He didn't even
suggesting
know
that.
about Gray.
I'm not
when he
suggesting
filed
that in
his-
this case that happened. I'm saying that if we adopt your position, it would be a possibility.
Well, it would be a possibility, Justice Cowan, but we have the adversary nature of the proceedings as a substantial protection. You've got a party that's represented by counsel that has ample resources and is in a position, and any time when allowing the late application would be prejudicial, either to the party or to the interest of justice, to bring that case forward. And it could be litigated and decided. So this system that is in place now is a very effective system. It works. It was, as it happened, Mr. Foxworth's circumstances beyond his control actually occupied the entire 4 years. But at any point during the Alfar proceeding, that could have been tested, and it wasn't. It was waived. It evidently was not a problem. And also the question of what law should apply can be litigated during the Alfar process, and it can be litigated during the consideration of the merits. So there aren't really, I don't think, any problems with the way this system is being operated. The clerk's office did an excellent job in this case. They made sure that the Commonwealth was notified of every step of the proceeding in this further appellate review process.
Thank you, Mr. Thompson. Ms. Learden?
Good morning, Your Honors. May it please the Court. Suzanne Reardon, Assistant Attorney General on behalf of the respondent in this case. The rule or the answer to the certified question that I'm proposing, I would suggest allows the Court the flexibility to accept...
Ms. Learden, here's the problem that I have, just to pick up on Mr. Thompson's point. In October 2002, there was nothing to prevent the Commonwealth from coming in and saying, excuse me, court, you should be aware of the fact that if you allow this motion to file late, there has been a change in the law, and specifically the change in the law is Gray against Maryland, and you should keep that, I mean, here the defendant is raising it, and you should keep it in mind that if you allow this motion, he's going to get the benefit of that. The Commonwealth did nothing. Nothing. I mean, you know, we have hundreds and hundreds and hundreds of applications coming through. Why can't we rely on, as Mr. Thompson says, the adversary system to point, you know, to say to us, don't grant this, do grant it?
Well, Your Honor, at the time in 2000, when the late application was filed, at that point the Commonwealth, really what would have been granted was the late filing of the FAR. At that point, the direct appeal process was not reopened, and I would suggest it was not reopened unless and until this court granted further appellate review.
But isn't the standard law, if you know, if you file an FAR within the 20 days, it stops the clock,
Yes.
correct? If you have 20 days within which to file a motion to dismiss. If a court grants a motion to dismiss, right, and then you file a motion to dismiss and the court rules on a motion to dismiss, the case is heard as if it's never stopped. In essence, by allowing a late filing, you're putting the clock back to where it was. I mean,
If
that's...
it's filed within the 20 days.
Yeah, that's sort of black letter law, criminal, civil, all over the place.
If it's filed within the 20 days under the rules, I agree.
No,
it's
but
filed
and
4
then
years
if you allow a
later-
late filing, you in essence are putting it back within the 20 days.
No.
I would suggest no, not unless until the court allows further appellate review, the conviction remains final. This conviction was final in 1996 when the rescript issued back to the trial court. That an application for further appellate review, which would have stopped that clock, was not filed within the time allowed for under the rules.
And if we had then a motion for ineffective assistance of counsel, because it's clear that this wasn't a manipulation, somebody didn't file an FAR, not because of this defendant's concern, so now you go to Justice Spina's question. Do we
Then
now
that-
have to have a hearing as to whether or not the failure to file an FAR was ineffective assistance of counsel?
I think if the application for further appellate review had been filed within the 20 days, this defendant would not have had Gray to rely on. And the appeals court decision, which was issued at the time of Bruton and Richardson, would have been upheld, as the First Circuit has found that at the time the appeals court ruled on this appeal, it was in line with Supreme Court precedent at the time.
Would it make any difference to your position if we had a procedure in place that said, with respect to late applications, that there be a statement of the merits of the appeal in the motion to file late? Not only that there was excusable neglect, but we have a meritorious claim here. Does that make any difference?
You could make that rule. I think then it might be combining the two issues, whether you could late file it and whether it meets the standard.
Okay, now here, as a practical matter, that's exactly what happened, because they laid out in the application for late filing.
Well, I would respectfully disagree with that. When the late application was filed in 2000, Gray was not mentioned. Gray was not raised in this case until the amended application for FAR in 2002, after he had gotten counsel.
Okay, but it was in the 2002 application. Everybody
That's after the late file was allowed.
everybody knew that Gray was a critical issue in the further appellate review, in the late filing.
You said that was after the late motional? I'm confused about the sequence here,
It's
because
a
the
little
docket's
bit
not very helpful.
unclear. The first application for late filing was filed in 2000. It does
October
not look like
2000.
that was acted on until 2002, as far as I could tell from the docket. And not until
Well, in December of 2002, those proceedings, whatever the further appellate review proceedings were stayed because the defendant informed the court that he was or had a counsel was going to file a motion for a new trial, correct?
correct. And so the proceedings were stayed for that, and those proceedings, I might add, which went again up to the appeals court, did not include Gray either.
Now, imagine that you were in consultation with us, considering this case, and imagine that the question arises during the course of that consultation as to whether or not we are to consider Gray to be applicable law in deciding whether to take the FAR. What is your answer?
I would suggest that, I guess that was up to the court to decide if, considering Gray, this case met the standard of 27.1. The court apparently did not.
Can I just
So
ask?
I would think the court, I'm not going to read into what the court decided, but I would
But
think
the
that
question is not what the
decided-
court did decide. We don't know that, because I wasn't there, nor were you. But the question is, should this court consider Gray to be applicable law in deciding whether to take the FAR?
Can I just ask Justice Gans, are you talking about a late filed or
Late filed, in this
late,
case.
a late
In
filed?
this
Okay,
case.
okay. I assumed that, but okay.
In keeping with my argument, I would suggest no, because the conviction became final in 1996. And in keeping with all the interests of finality, not just from the state courts, but in the federal courts as well on habeas review, they continually look at the interests of finality in state court convictions. And oftentimes on habeas review, when further discretionary review is denied, they look at the last state court to have looked at the issue, which in this case was the appeals court. And at the time the appeals court ruled in 1996, the applicable Supreme Court case law did not include Gray.
But, Ms. Ridden, I thought your position was if we had allowed the application in 2002 or 3, that the petitioner would be entitled to, because that would reopen the appeal, right?
Okay, yes, I'm sorry. So if you had allowed further appellate review, that would have
So
reopened
Gray
the
would
direct-
apply.
Yes. So I guess we
but-
would be in a different position had you allowed further appellate review.
But
Right.
that then goes to
Reopen
but that then goes to Justice Gans's question, I think, because if either way it's not consistent, unless presumably you have a determination that there was ineffective assistance of counsel, because had the application for FAR been filed in the normal course, i.e. within 20 days of the October 1996 affirmation in the appeals court, this defendant would not have had the benefit of Gray in any event. So even if we had allowed the application, you're saying, well, then you just get the benefit of, this defendant gets a benefit that somebody else doesn't get.
If you had allowed the application in 1996.
No, in 2002 or whenever it was.
Yes, if you had allowed it, I would agree that the whole conviction then is reopened. And
What do you do with the question about whether, let's say, the application for a late FAR in 2002, in this case, is because of some issue over here, let's say of drug certification or something or other, and it turns out that there's been a whole new development of law, you're saying you just open up the whole case?
Yeah. You mean if it's an issue that hadn't been raised on intermediate level?
In the course of the application, but then when the brief comes in, because you've opened up the whole thing, maybe you've waived it.
I think that would probably be the answer then. If it's a completely new issue, there may be an issue of waiver if it hadn't been
Well,
raised.
for example, if the application for, had been the second motion for new trial, which was on, I don't remember what the ground was, but it wasn't this one, and this had come up, and in the meantime, there's Gray out there, would we be able to look at Gray and say, well, it hasn't been argued, but your Bruton issue is a very good one?
Well, in this case, because Bruton had been raised throughout in the direct appeal, and this is, I would argue, just an extension of Bruton, if the court had reopened the conviction in 2002,
He would get the
have to
benefit.
say it's all open again, yeah.
Could I ask you this? If we decide in your favor on this point, this defendant can file a motion for a new trial, because you can file that at any time. Can a superior court judge, I take it this is a superior court, can a superior court judge then consider the Gray issue?
I think the Commonwealth would probably argue waiver at that point, because the Gray case came out in 1998, and after 1998, he had filed a motion for new trial and didn't raise it.
But he could combine it with an ineffective assistance, couldn't he?
I suppose he could, but really the ineffective assistance, if you're going to argue the ineffective assistance was that he didn't file an FAR application on time, it doesn't really work, because the application should have been filed in 96 before Gray.
And you look at the law as it was in 1996 on an ineffectiveness claim.
I think so.
For a late filed FAR, what do you call that if not direct appellate review?
A late filed FAR
Right.
is just asking for permission to file an application to be
Okay, and
considered.
it's allowed, and then the court then reviews it on further appellate review. What do you call that? Do you call it direct review, or do you call it something else,
Further appellate review, which is discretionary.
which is direct review?
It's direct review.
It's an extension of direct review if accepted.
So,
No, but you're saying if accepted, but while we're in that little space between having allowed the motion and looking at the application, we don't know whether we're going to allow or deny the FAR, the merits of the FAR. What is that?
It's the time during which the court is deciding whether the defendant has met the standard of 27.1.
okay, but generally it's either direct review or collateral review. Are you saying there's a third category? Or
No.
I mean-
Isn't your argument that if you did it timely, it would be under the rules, it would be part of the direct appellate review? If the rescript issues and you do it late, it isn't anything until it's allowed, and then it is part of direct appellate review.
That's exactly what I'm saying. I think this is just in the cases where...
Are there any others? What does the United States Supreme Court do? What's its position? A
Well,
late
the
filed petition for cert.
The cases that are cited by defendant, by and large, involve cases where a late direct appeal is allowed, or a notice of appeal is late, and a court accepts a direct appeal late, which in that case, once that late appeal is allowed, the direct appeal continues. Those cases, by and large, don't involve discretionary review, such as further appellate
That's why I
review.
asked you about the petitions for cert.
If you don't bring a petition for cert within 90 days.
And you
isn't that
file
the
a
rule?
late
Yeah, so you
application
file
for late
what
file, and
happens
then you file it at 120 days or 900 days or 1,000 days, and it's allowed. And then the petition for cert is denied. Do you know what the practice of the Supreme Court is?
In terms of reopening a conviction? I mean,
Yeah.
at that point, the conviction...
Or it's not just a conviction. It's civil cases, it's criminal cases, it's all kinds of cases. It's not just this case. It has enormous ramifications for all of our cases.
I don't know if there's a Supreme Court case that talks about late cert petitions. I know that the Jimenez case and the Limitiaco case, which are cited, talk about out-of-time direct appeals. I would suppose that if there's a late cert petition filed, not unless cert is granted, is the conviction...
But you're supposing, so the answer to my
Yeah,
question is you don't know.
have a
What about
case
other states which
exactly.
have a discretionary review at this court of last resort? Do you know how that's viewed?
I'm sorry.
What about other states which have, courts of last review after an intermediate appellate court where it's a discretionary decision? Do you know what their views are?
I haven't found any that talk about discretionary review. A lot of the cases that petitioner or defendant cited to in note 12 of his brief, most of those cases also talk about out-of-time direct appeals. Once those are allowed, yes, the direct appellate process continues.
What about the ones that are denied? I mean, it's very unusual at the first level of appeal. That's the difficulty. It's a far more consequential thing to deny any party, civil or criminal, no appeal.
Right.
So if there's been so those I think are almost routinely granted, unless it's for manipulation of the system.
Yeah, and that's why I think the rule that I'm proposing works, because it
I
gives the
suppose my
court-
question is, has any other court anywhere in the United States followed your rule?
I don't. Well, I don't guess I don't have a case exactly on discretionary review. What I will point the court to is the Beard v. Banks case, the Supreme Court case. In that case, a direct review of a state court conviction ended, and 8 months later, the Supreme Court came up with a new rule, and the Pennsylvania trial court decided the case on this new rule, on the merits, and denied relief. And then on habeas review, the petitioner said he was entitled to this new rule because the state court had considered it, and the Supreme Court rejected that argument, saying that even if a state court declines to enforce their available procedural bars and chooses to apply a new rule, that doesn't change the finality once a case has already been final. So that's probably the most applicable case.
But that was plainly collateral review.
Yes.
But and I'm still not sure what you call this decision that we make that decides whether or not to take FAR. Is that not review?
It's allowing a case to be filed. In this case,
No, we already allowed it to be filed. We already allowed it to be filed. Now the question is, should we accept further appellate review? That's a decision by this court. What do you call it? Do you call it? Apparently, you call it nothing. You don't call it collateral review. You don't call it direct review. What do you call it? It's review of a decision below to decide whether or not we should accept it. What do you call that?
I guess I call it, the time within which the court is deciding whether to accept it for further appellate, just as if a petitioner...
The answer is I don't know.
Yeah, I guess I don't know what to call it, but my argument is that unless and until the court accepts it for further appellate review, if conviction has already been filed.
Does it surprise you that there's no other court anywhere in this country that has proffered this as a rule?
I mean, I don't know whether it had really come up. I mean, this is a very unusual circumstance that the First Circuit is asking this question. I think, frankly, it could have decided the case based on that Beard v. Banks case. I guess it just wanted to give this court input as to what its decision meant in 2002.
Thank you, Ms. Levy. We're going to take a short recess.
All right.